Acceptance is a crucial element in contract law and refers to the offeree's agreement to the terms of the offer made by the offeror. Acceptance, when communicated to the offeror, forms the basis for a binding contract. Here are two examples of cases involving acceptance. Case 1, Carlill v. Carbolic Smoke Ball Company. 1893. In this landmark case, the Carbolic Smoke Ball Company manufactured and marketed a product called the smoke ball that claimed to prevent influenza. They published an advertisement offering a reward of £100 to anyone who contracted influenza after using their product as directed. Mrs. Carlill purchased and used the smoke ball but still contracted influenza. She claimed the reward as per the advertisement. The company argued that it was a mere sales puff and not an offer. However, the court held that the advertisement constituted a unilateral offer, and by using the product as directed, Mrs. Carlill accepted the offer and was entitled to the reward. This case is significant because it established the principle that acceptance of a unilateral offer can be by performance of the requested act, rather than by express communication. Case 2, Feldhaus v. Bingley, 1862. In this case, Mr. Feldhaus wanted to purchase a horse from his nephew, John Feldhaus. He sent a letter to his nephew, stating, "If I hear no more about him, I consider the horse mine." John's silence was interpreted as acceptance by his uncle. However, John had previously mentioned to an auctioneer that the horse was not for sale. The court held that silence or inaction alone does not constitute acceptance unless there is a prior course of dealing between the parties indicating acceptance by silence. In this case, since John had previously expressed his intention not to sell the horse, his silence did not amount to acceptance. The court ruled in favor of John Feldhaus. This case illustrates that mere silence, without any indication of acceptance, does not create a binding contract. These cases highlight the importance of communication and the various factors that can determine whether acceptance has occurred in contract law. It is essential to understand that acceptance must be clear, unambiguous, and communicated to the offeror to form a binding contract.